And we now recall cause number 22-39733, the state of Texas versus Ankur P. Patel. The defendant is charged with a third-degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior convictions. The court has received a message from the jury that the jury has reached a verdict in this case. I'm going to ask the bailiff, please call forth the jury, and we will accept the verdict. We also have alternates that we can bring the alternates. Thank you. Yeah, wait. Yeah. Fill it in. We'll see. We're going on track. And the record shall show that the jury is seated in the courtroom. All parties, including the defendant, are present. Mr. Cepeda, I believe you are the jury foreperson.
Yes.
We have received a message on behalf of the jury that the jury has reached a verdict in this trial. Is that true?
Yes, you are.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, you are.
Do any of the jurors disagree with your foreperson's representation? No disagreement is indicated. It does indeed appear to be unanimous. I'm going to ask you to please pass the documents to the bailiff. I will review for proper form and publish the verdict, and you may be seated, sir. Thank you. Defendant shall rise. In cause number 22-39733, the state of Texas versus Ankur P. Patel, we, the jury, find the defendant guilty of the offense of felony driving while intoxicated as charged in the indictment. It is signed by the foreperson. It is received by the court and made a part of the records for all purposes. You may be seated. Ladies and gentlemen of the jury, I have received your verdict finding the defendant guilty of this third-degree felony of operating a motor vehicle in a public place while intoxicated. And that brings us to a close of this trial because, as you know, the defendant has elected to have the court decide the punishment if and only if he was first found guilty by the jury. And what will happen is I will order a pre-sentence report, so I will know the probation office compiles that. I will know background about the defendant.
On a jury request book.
I'm sorry.
Yeah.
Oh, I'm sorry. That's right.
Yes.
Come on up. Come on up. Yep. My fault. You know what threw me off is that first
Yes, sir.
there was an election that was inadvertently submitted.
Right.
And that's still here on the records, and I'm forgetting about this. All right. What's going to happen, ladies and gentlemen, is we're going to next move to the punishment or second phase of the trial. You will be continuing to follow the instructions previously given to you in this case, okay? Stand by.
When people in the area lost shelter, I accommodated some 25 rooms for the city department as well as the police department involved in Port Arthur.
Did you charge them for these rooms?
Reasonable charge, not what I'm supposed to charge the other companies about. depending on the recording or whatever is approved by the local.
More. It needs to be 20 degrees the other way.
This one.
The other way. Keep going. Keep going. Stop. Thank you. Go ahead. Go ahead.
We have automatic adjustment to the camera. It's called Lacey. Okay, in this volunteer work you've done, are you asking the jury, when they assess your punishment, to give you probation so you can continue this work?
Actually, I will still continue because even before DWI, I was doing this work.
Right. But
Since 2007.
if they arrive at a punishment for you, you'll continue to do this volunteer work.
I am continuing already. That's what I mean to say. I
Oh,
never stopped.
okay.
Uh,
My
well,
question is, should they send you to prison,
oh,
how are you going to do the volunteer
that will
work?
stop.
Oh, okay, there. And whatever the conditions of this new probation from Judge Stevens are, that he gives you, you're going to follow those to the letter. Are you going to drink?
No, not under any circumstances from now.
Okay.
I understand the challenge that what is faced right now.
Okay, you understand you can't drink alcoholic beverages, period. You have to say something.
Yes.
Okay. Pass the witness.
Mr. Patel, you said earlier you testified that you still drink occasionally. Is that correct?
Occasionally, but sometimes when I'm completely off and I have a driver, but not like when we have occasion, it's like once a year. Basically.
And you still do that after you had the 2 convictions and after you had the alcohol class showing
below,
you?
below 0.8. Below the limit, one of this, but we technically, I would say, I don't drink in that country at all. I have never drank.
And you just said that if you're placed on probation in this court, that you would follow the conditions of that?
Yes.
Did Or on July 30, 2020, you also said that you'd follow the conditions there in that probation too as well, didn't you?
Yes. But I explained, it was after 2.5 hour after lockdown period event, and like you never had it like every week or every month or something. It was completely a different day and a different year, which came out to be.
So, but you told the court in this case that you would follow those conditions as well, right? And you signed your name to it.
Help him out. He's
Yes, actually.
In the county court here at number 3 in Jefferson County, and this DWI from July 30th, 2020. Did you understand that this is a probation order in which you pled guilty? Said that you understand that you had to follow all the conditions of that probation?
they can't see him.
That's your signature?
Yes.
But you didn't follow those conditions of that probation, did you?
Only once
When did you follow them?
when I had this incident happen. That was only once that happened.
When you drank alcohol on February 20th,
Yes,
14th?
that was only one. The rest of them was false.
Now, in the other probation, did you do your community service hours?
I still do the community work in the community I'm in.
But on the probation from Chambers County,
In
did
the
you
classes.
do your community service hours there? Now, this, instead of you,
When the Chambers County, was in at the time I remember I had a lot of work on my end to fix in the area because we were suffering from the Hurricane Harvey. And I had to fix two of my hotels, which was flooded 4 feet underwater, which took 2 years to develop.
so that court, they found that you didn't complete your community service hours, right? And did you pay some money instead of that?
I had an option because I was still working for my business, because that was a priority at the time. It took me 2 years to develop. I could be more than happy to share some damages, pictures, and the work performed during the time.
So how many times is it gonna take for you to get arrested not to drink and drive anymore?
I'm done with that. I never hold the steering at all. And we're talking about 4 years before. Today my kids has grown. They're heading to the high school. So the days, the time, the challenges have been changed than what it was before.
And you still drink occasionally?
No, when I say occasionally, it's not like the way what I'm gonna be doing that. It's like almost not drinking like that.
Okay. Is that kind of like you were pretty much okay when you were on the road that night on February 14th? When you testified, you pretty much thought you were okay on the February 14th, 2022?
I would make it for 1 mile. I would preach home before I got the water.
Okay. But you saw some probation videos, huh, where people were killed in accidents?
No, I totally agree, and that's what I never wanted to be that way, and I feel the seriousness of it. But I did my best, and I want to be responsible, even if I drink. But right now, it's not my priority. I understand what I'm facing, so it's not the importance that I should drink or not. It's not. It's not. And I haven't even done it in the last 4 years. If you see it, that was only one day I just got to be in a problem, and that's it.
What kind of treatment have you received for dealing with alcohol?
I just self-treated myself, and I lost weight. I had to do some fitness, and that's it. But mental health is the main, and I wasn't addicted to it, honestly, because I already stopped it even before when I got the probation. I had stopped that. And it was just a day when we just get together after lockdown, but even that is over now. Those days never come. I don't drive after 9 o'clock anyways.
So you don't have a drinking problem?
Not at all. I don't drink every day.
Yeah.
When I say it's like not even once a year, honestly, let me put it that way.
That's what.
Anything else?
Nothing.
And you can test you.
You can take your seats, friends. Next, record shall show the jury is seated in the courtroom and all parties are present. Ladies and gentlemen, the court has prepared a jury charge for you. It's shorter than the first jury charge of the guilt or innocence phase. This is for the punishment phase of the trial. And again, please listen carefully as I read this charge to you as well. It will be left with you to refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of felony driving while intoxicated. It now becomes your responsibility to assess the proper punishment. This offense under our law is a third-degree felony. Third-degree felony punishment. An individual adjudged guilty of a felony of the third degree shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for any term of not more than 10 years or less than 2 years. In addition to imprisonment, an individual adjudged guilty of a felony of the third degree may be punished by a fine not to exceed $10,000. Good time credit and parole. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignment, and attempts at rehabilitation. If a prisoner engages in misconduct, the prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be imprisoned might be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant if he is sentenced to a term of imprisonment, because the application of these laws will depend on decisions made by prison and parole authorities. Now, you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. And that's because that's not in our hands. It's with parole authorities' hands. And you are not to consider the manner in which the parole law may be applied to this particular defendant. Now, instructions on probation. The defendant has filed an application for probation. Probation means the release of a convicted defendant under conditions imposed by a court for a specified period during which the imposition of sentence is suspended. Our law provides that after punishment is assessed, the jury may recommend probation of that punishment if, one, the prison term assessed does not exceed 10 years confinement in the institutional division of the Texas Department of Criminal Justice. And two, the jury finds that the defendant has never before been convicted of a felony in this or any other state and recommends probation. Our law further provides that if a jury recommends probation, it must be granted by the court. Now, your first responsibility is to assess what you believe is a proper punishment for the defendant in this case. Then, if and only if the prison term you assess does not exceed 10 years confinement, which that's the top limit you can assess in this third-degree felony, you may consider granting the defendant probation of that punishment should you find the defendant is legally qualified to be placed on probation. Now, if you grant probation, you place upon the court the responsibility to supervise the defendant. And in discharging this responsibility, the court may impose any reasonable terms and conditions designed to protect and restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You are allowed to assess a punishment term of 10 years or less and not recommend probation. You are further allowed to grant the defendant probation of the penitentiary term, a fine if one is assessed, or both. If you grant the defendant probation and the court subsequently finds that the defendant violated one or more conditions of probation, the court may either continue, modify, or revoke the defendant's probation. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it is not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. And in this case as well, in this part of the trial, your verdict must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. There are two sets of options available, ladies and gentlemen, and four individual options. Only one verdict form can be signed, by the way. First option, we, the jury, assess the defendant's punishment at confinement in prison for a term of blank years, a place for the foreperson to sign, and if that is the applicable decision that the jury unanimously decides, that would be no less than 2 nor more than 10 in that space. Second option, we, the jury, assess the defendant's punishment at confinement in prison for a term of blank years, no less than 2, no more than 10. We further assess a fine of blank dollars, not to exceed $10,000. So assessment of a term of imprisonment plus fine are part of this verdict. A place for the foreperson to sign. Your third option. The last two deal with probation. We, the jury, assess the defendant's punishment at confinement in prison for a blank years, no less than 2, nor more than 10. We further assess a fine of blank dollars, not to exceed $10,000. We further find the defendant has never before been convicted of a felony in this or any other state, and recommend that this punishment be probated, a place for the foreperson to sign. So if this is the one you decide unanimously is the answer based upon the law and the evidence that you decide for punishment, then the defendant would be sentenced to a term of imprisonment. Then that would be suspended, probated, and a fine of up to $10,000, whatever you decide, would be assessed as part of the punishment to include the probation. And finally, we, the jury, assess the defendant's punishment at confinement in prison for a term of blank years, no less than 2, no more than 10. We further find the defendant has never before been convicted of a felony in this or any other state and recommend that his punishment be probated. And we further assess a fine of blank dollars. So here, the confinement would be probated, but the assessment of fine would be required to be paid by the defendant. Does everybody see your four options? Only one verdict form can be signed by the foreperson on behalf of the jury. As before, the state of Texas may open and close final arguments for the punishment phase. What says that?
Your Honor, we waive our right to open and reserve our right to waive.
You may. Mr. Macon, on behalf of the defense, you may go forward.
Well, earlier I said, talking to a jury right after the judge has said nothing I say is evidence. That's not the most difficult. Arguing punishment is, because everything I obviously said and argued before, you decided wasn't applicable. So here we have what's the proper punishment for Mr. Patel. And the only evidence you have is that Mr. Patel has never been convicted of a felony or this or the other state. And that qualifies him for probation. You've heard he's a businessman here locally. He volunteers. And if you decide to give him probation, Judge Stevens supervises that. He can impose all the conditions of probation and watch them. He can have a zero tolerance policy. you know. And he gets to decide what's proper. Now, there are many, many things that could be part of that. So in arriving at your verdict, after you decide whether it's going to be prison, what period in there, then you look at these instructions for probation. And one, the prison term can't exceed more than 10 years. That's the maximum here. And then you have to find that he's never been convicted of a felony or that in this or any other state. The only evidence is he's never been convicted of a felony. And if you recommend that, then the judge will follow it and act accordingly. And it gives you instructions on how to arrive at that. Then you get over here to the verdict forms. Now I'm suggesting to you that the verdict form you should fill out is: we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of somewhere 2 to 10 years. We further find the defendant has never been convicted of a felony in this or any other state and recommend that this punishment be probated. Then you further assess a fine of $0 to 10,000. That would not be probated. He would have to pay that while he's on probation, and that would be supervised by this judge. Now, another form on there deals with the same judgment of prison and a fine of up to $10,000. But that goes further to find that you probate not only the sentence in prison, but also the fine. It's up to you. But he supervises that. Would you want your life to be supervised by Judge Stevens? He would issue certain rules and policies and requirements, and Mr. Patel would be, compelled, or he would go and have his probation revoked. The judge may very well order upfront jail time in the county jail as part of the probation. It's whatever he deems appropriate. A lot was said about the fact that even though he got probation before and did all this, he drank. And you heard him testify. He didn't understand. But now he does. And he's told you he won't be drinking. And this judge will supervise that. I look forward to your verdict. Thank you.
State of Texas.
What do we do with someone who just won't stop doing the same thing over and over? It's not an easy thing, but here's the facts. Let's look at it. On June 27, 2017, Mr. Patel commits the offense of DWI with a blood alcohol content of greater than 0.15 in Chambers County. On November 27, 2017, he pleaded guilty to that. And he received 365 days county jail, probated for 15 months. So he received 15 months probation with all those same conditions that he required, a lot of the same stuff that he's required to deal with every probation. And roughly 8 months after that, on July 12, 2019, he committed the offense of driving while intoxicated in Jefferson County, Texas. On July 30th, 2020, he pleaded guilty to that offense and was sentenced to 180 days county jail, probated for 2 years. So he got another 2 years probation in this case. And approximately 1 year, 7 months after that, on February 14th, 2022, he commits the offense of driving while intoxicated, a third offense. Each one of those probations should have caused him to wake up, right? He's facing jail time in each one of those. And I like to think of it, what do you do? What would you do if that was your kid, right? We progressively kind of sanction them and get onto them to correct their bad behavior, right? If they're doing something dangerous to themselves, to others, just doing something wrong, we step it up. We might take some from them the first time, might warn them the first time. The next time, they do the same exact thing. We're not talking about doing something different. We're not doing something else. Doing the same exact thing. You said, don't do that again. And they do it again. Not that much longer after you told them not to, or after you just got through with your punishment. You punish them for 30 days, and guess what? They just did it again. And you punish them again a little bit harder this time, right? Still threaten them, saying, hey, you're gonna get a little more next time. Don't do this again. What do? They do it again, a third time. I know in my house we usually didn't make it a third time, but let's just say you usually got a little butt whooping by then, right? You got a little, but it got worse each time, right? Trying to get, not because you're angry at them, not because you think they're bad. It's you want to protect them, right? You want them to be good and to learn to do right. And that's the whole thing here. We're not saying Mr. Patel's a bad guy, but he won't learn. What does it take? Does it take him running into someone else and killing them? I mean, this is your community. You get to decide who's driving on your roads and what message you want to send to those individuals doing this. And I know a lot of us, we think, oh, because no one was hurt, so nobody. And I get it. It's hard to understand. But when somebody wants to do this over and over within a fairly short period of time, and then I would even say if he got up here and said, I have a problem, I've been working on my problem. He doesn't think he has a problem. He gets up there and makes excuses for everything. What would you do with that? Think about it. You're facing your kids and they make excuses for it. They've done the same thing over 3 times. Now they still won't even say, yeah, you know what? I need some help with this. I need to get in line and I need to. No, he still drinks occasionally. I tell you what, if I was facing prison time, I wouldn't be drinking at all. I wouldn't be messing around for drinking and driving. And yet he still got an excuse for everything that he'd done. It was the officer being too harsh on him. I don't even know what he finally came up with, the bottle or whatever it was he searched in the middle of the road. He just can't come clean. And the only way you can fix that problem and truly say, okay, well, probation might get it and he'll stay safe, is if he's saying, yeah, I got a problem. I need to fix this problem. He won't say he's got a problem. And he's already been told by the court and he promised that he's going to follow those conditions. And what did he do? While he's still on probation for the other one. Think about it. Your kid's still punished. They go do the same exact thing after they've done it twice. They went and did it again while they're still on their punishment. What do you do with that? You just step it up a little bit, right? And that's why I don't think probation is appropriate in this case. I don't think the 10 years is. I don't think Mr. Patel is an evil guy, but I think we got to send a message to Mr. Patel. You need to wake up. And I think before he kills himself, kills someone else, he needs a wake-up call. And I think 2 years in the pen is the right number. It's on the low end. We're not trying to hammer him. But we're trying to send the message. This needs to be a wake-up call for him before he hurts somebody else, before he hurts himself seriously. And this, like I said, this is your community. You get to decide that. You get to decide what message you're going to send someone who keeps getting on the road, highly intoxicated like that. Remember, it was over 0.15 in the other case, and it's over 0.2 in this case, 0.213. Getting progressively more. And I would say he does have a problem, and that needs to be addressed. The only way he's going to take it seriously is by actually giving him a little bit of time. So that's what I'm asking you for. I know it's not an easy decision, but I ask, it's kind of like a parent having to do the tough thing. You say it hurts you as much as it does them, but sometimes you gotta give them a little whooping. And it's I asked you to do that and sentence him to 2 years. Thank you.
Ladies and gentlemen of the jury, I am handing to the bailiff the verdict forms and the charge for this punishment phase. I ask you, please follow him into the deliberation room and we will wait. Alternates, same as before. Thank you very much for your vigilance and patience.
No, it's not a right of appeal.
How does this form here that you gave me with the summons?
No, I think he gave you,
No, I just
the
gave you the
discovery.
certification.
Yeah, that needs to be signed for his appeal, or else the appeals will make all the matter.
It's not a keyboard case. So we can't do it. Sign your name.
We now recall cause number 22-39733, the state of Texas versus Ankur P. Patel. The defendant was indicted for the third-degree felony of operating a motor vehicle in a public place while intoxicated due to 2 or more prior convictions of DWIs. The defendant was found guilty in phase 1 of this trial, and the jury has reached a decision in the punishment phase of this trial. I'm going to ask the bailiff, please call the jury forth and we will receive the verdict.
Right.
And we're going to need the alternates.
Okay.
You have all the paper.
Is
And the record shall note that the jury is seated in the courtroom. Mr. Cepeda, as foreperson of the jury, the court has received a message that the jury has reached a verdict in this second or punishment phase of this trial. Is that true?
Yes, Your Honor.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, Your Honor.
Do any of the jurors disagree with your foreperson's representations? No disagreement is indicated. And as before, I'm going to ask you to pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause 22-39733, the state of Texas versus Ankur P. Patel, we, the juror, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 2.5 years. This is signed by the jury foreperson. It is entered into the record, and the defendant, the jury elected not to place the defendant on probation. Ladies and gentlemen, at this time, your duty as jurors is completed. At the beginning of the trial, I placed each of you under a number of instructions, and at this time, I am releasing you from these instructions. One final instruction, though: once you are discharged, you are released from your oath of secrecy. You will be free to discuss the case and your deliberations with anyone. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by me. In a few minutes, the attorneys are going to be discharged, and they always like to touch base with jurors. If you're willing to stay behind and talk to them, they like input and feedback. It helps them in their job. They're always curious about what can they do to, what did you find important, not important, and helpful, not helpful, and it makes them better lawyers. And that's a good thing if you're willing to stay behind. My coordinator, Lacey here, has documents as well for work or school or other purposes that reflect that you've been doing an important job here because you weren't at work or for other reason. And she has those for you. I hope to have the opportunity to work with you in the future, ladies and gentlemen. And you probably are thinking, I guess he was right at the beginning. This isn't anything like television shows. This is real world, real life. You get to share now, if you wish, your experiences with others. And that's always a good thing because we want good and fair people to be available for jury duty. You had a very interesting case here, and there probably isn't a more important time of the year than right now for such a case to be presented. I'm just reading the National Safety Council estimates over 500 fatalities during the Christmas holiday period. And Christmas and New Year's are the most tragic time periods for driving and fatalities. And each of those fatalities represent somebody's child, parent, neighbor, friend who won't come home. But these losses are preventable. And like drunk driving impaired driving is illegal in all 50 states in this country. And also about 25% of driving impaired are dealing with issues such as drugs. But we know that this is the time of the year that we've got to be really extra careful. And most importantly, remember that a motor vehicle is really nothing more than a 4,000-pound missile. It has to be operated responsibly. Lives are at stake, not only the operators, but all of those who share the roadway and share in responsible driving for the selfless reasons that we all feel like Americans should be. So if those of you are going to choose to drive during the holidays, call a friend, a sober friend, rideshare or text or some public transportation. And if you're hosting get-togethers during the holidays and people are impaired from the fun and enjoyment at the party, please take their keys, get them home safely. Saving lives is the greatest gift we can give to one another. Ladies and gentlemen, may God continue to bless Jefferson County and her citizens, and thank you for your service, and you are excused. Everyone else may remain seated while the jury exits first. Have a good day, you too. Thank you, sir. Thank you again. See you next time. And is there any legal reason why formal assessment of judgment in this case should not be rendered at this time?
Not that I know of.
Ankur P. Patel, you came before this court and a jury. You entered a plea of not guilty to the third-degree felony of operating a motor vehicle while intoxicated. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this third-degree felony of driving while intoxicated. Thereafter, the jury was presented additional information and was instructed by the court. The lawyers made their final arguments. They retired for the punishment phase deliberations, and in their deliberations, they deemed your punishment should be assessed at confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2.5 years. Therefore, it is the judgment of this court that you are guilty in this cause number 22-39733, and you shall be punished in accordance with the jury's verdict. Therefore, your punishment is hereby assessed at confinement in the Texas Department of Criminal Justice's institutional division for a term of 2.5 years. You shall be ordered to be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's institutional division or any other person legally authorized to receive such convicts, where you shall be confined for 2.5 years in accordance with the laws governing the Texas Department of Criminal Justice's institutional division. And you are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions of this sentence. Your sentence shall commence on this day. You will receive credit for all time periods of detention as provided by law that you may have served in connection with this case. Anything to add by the parties?
Nothing from the state, Your Honor.
Defense.
Your Honor, I don't know if it's the proper time, but after Mr. Patel goes into custody, we would ask that an appeal bond be set.
What does the state say on that?
Judge, since he was on probation when he committed this, you would be setting the same kind of conditions on bond. I don't see something that he would be able to comply with. So we would ask that the bond be denied.
What about that?
Your Honor, I don't think he had a GPS monitor or a drug patch on him, and I think any new bond while in appeal should require those. He's a local businessman. He's not going anywhere.
Now, in the testimony, let's take this one at a time. When he was placed on probation in 2017 out of Chambers County, he was placed on probation in that case, and there was an irregularity on the maintenance of that probation, wasn't there?
Just, I think that was just community service, but it was waived, and I think he paid money for it.
Yeah.
Just to be honest with the court. That was,
Okay.
Yes, sir.
So he was convicted in 2017. When did his probation conclude? I don't have that information.
It was February, I believe, was and then
Of what?
of 2018. You got those judgments, or are they back there? Okay. I can.
Where?
On Pim's bill.
It was about.
Where are they? In Kim's?
On Pim's.
Okay, can somebody get those? Let's refer to the judgments. There's 2 judgments on the defendant. Let's get those on the record because that information was not presented on the record about when he was released. And thank you very much. I'm looking at the 17 CR 360, the defendant's first case where he was placed on probation.
Sorry. I show the order of discharge was in 25th day of March
15 months.
2019.
Yeah, 15 months of probation.
Yes, sir. There should be an order of discharge from community supervision with the paperwork, and it says it's dated March 25th of 2019.
Okay. So he is released from supervision in March of 2019.
Yes, sir.
What date? March of what?
March 25th.
Okay. Less than 4 months later, he is arrested at 2:32 a.m. on Highway 365 for a DWI and then charged with the misdemeanor offense and was convicted on July 30th, 2020 out of the County Court at Law 3 of Jefferson County, Texas, and was sentenced 180 days in the county jail, and that was suspended for 2 years. And this was dated in a probation order of
At the top left-hand corner of the judgment, Judge, you'll see.
July 30th, 2020. And a year and a half later or so, he is alleged to have committed this offense of that the jury has just convicted him for a third DWI, for which they have sentenced him to 2.5 years in prison. Any terms and conditions of release that I would assess pending appeal would be no different than the terms of probation, essentially, that he received and failed to honor in 2000 for the 2020 case. And this court notes what we're talking about is a third crime involving the misuse of a 4,000-pound missile, which all too often we deal with tragedies in this court of intoxication manslaughter or intoxication assaults involving vehicles, where we have long ago became just tired of listening to the wailing and the crying of victims and the loss of lives, but because of the irresponsible use of a motor vehicle. And Mr. Patel, operating a motor vehicle has a lot to do with character. If you are irresponsible, you're acting selfish because you don't care not only about your own well-being, but of other potential victims. Like I said, this is a 4,000-pound missile. And this court saw the evidence, and I'm sorry about what happened there for everybody, but this is the third time you are being held responsible for committing crimes involving a vehicle. And in this one, we all saw you fall off your feet and fell on the ground. You couldn't even stand up. And you're operating a 4,000-pound missile. Then all of our lives responsible behavior are at risk and jeopardy by your behavior and others like you. No, at this time of the year, this is even we're all most vulnerable because this is the time, as we talked about with the National Safety Board, this is where most people commit violations of inebriation with a motor vehicle. No, your request for a bond is denied. The people are going to be safe during this holiday season from your irresponsible behavior. And that's the ruling of the court. Anything else?
I think it's fair.
That is all.
Right.